Villalobos, you're charged with driving while intoxicated, second offense. You are facing up to a year in jail. It's also elevated to above a .15 as well. The state has moved to reduce this to a first offense. I want you to understand how lucky you are, because had they not, there would be a minimum of jail time that you would be doing as a second offense. Do you understand?
Yes, sir.
Yes, sir.
You have to understand that it is still a second offense. So you ever get into a car and have the faintest smell of alcohol and get pulled over, an officer's going to run your record. They're going to say, if it walks like a duck and it talks like a duck, it's probably DWI again. And next time, what are you facing? What happens next time?
Caution.
No. No. Prison. A minimum of 2 years in prison, a maximum of 10.
That's the moment right there. Pay close attention, because this is what judges often refer to as putting someone on notice. The judge is making sure the defendant understands exactly what is at stake if they find themselves back in court for the same type of conduct in the future. This isn't just a warning for today.
Years in prison. Do you understand?
Sí, señor.
Yes, sir.
Even if you had a sip of alcohol, I wouldn't get into a car. You're giving up a lot of rights by entering into this agreement. You give up the right to a trial, right to compel witnesses to testify on your behalf, confront and cross-examine your accusers. If you are not a citizen, there are immigration consequences. You can be deported, excluded from the country, denied naturalization under federal law. You give up the right to appeal. Once you plead guilty, this will go on your record. It will be there for the rest of your life. Now, the agreement is 1 year in Harris County Jail to be probated for 12 months. You must do a repeat offender DWI education class. You must also do 2 victim impact panels. You must also do a TRAS. This is an evaluation to see what other conditions you may need. If they assess further conditions, you must fulfill them. No breath test refusal. So while you're on this probation, if you get pulled over, an officer asks you to submit a breath test, you must do it. You must have a guardian interlock and 25 hours of community service. Do you have any children, Mr. Villalobos?
Yes.
If you do a parenting class, then I will waive the community service for you. You will now be required to also pay the DPS fines and fees and supervisory charges. If they had kept us a DWI second, you would be facing a $6,000 surcharge. But because they are reducing to a first and below a .15, it is only a $3,000 surcharge. But I want you to understand that if you don't pay it, for every $100 you owe, you will sit 1 day in jail. Your client is extremely worried about your immigration status, because if you go to jail, it's probably not going to end up well for you. Do you understand?
So,
Did this offense guilty or not guilty? I'm going to find you guilty. I'm going to follow the agreement. What is the total fines and fees? Trey?
yes, sir.
Total fines and fees. You must report at least twice in person to the supervisory department. If by then you are in compliance with everything, I'll allow you to report via Zoom. But that doesn't mean that you get to I expect you to remain in complete compliance. If you do not, a warrant for your arrest will be issued. I'm going to put you in jail, and I will bring you back out in Orange, and we're going to talk about whether you violated this probation. If you do, you are looking at 1 year in jail. Do you understand?
Yes, sir.
All right.
$3,520.
So it's $3,520 you will owe. Somehow we have to get your attention. I hope it's only monetarily and not through being in jail. You understand? Or at the worst, killing someone. Get a clue when it could have cost you $40 to $50 with an Uber. Good luck, sir. Thanks, Mark. Take care, guys. You know, Mr. Proctor, I told you that I wanted to follow whatever the TRAS said, you know, and shh, and I'm going to stick to that. You know, sometimes I'm surprised by what the findings are, but I trust them to make the right decisions, and I hope that you. So here, they recommended medically assisted treatment to address the alcohol abuse or dependency. That means that you have to go to a doctor, right? The problem is that we can't pay for that.
Right.
I can't pay for that. When it's on the outside, if it's here where they would have recommended like residential or something of this nature, I would pay for it for you. I can't pay for this. So you're going to be expected to do this on your own. You know, the other thing that they're recommending is intensive outpatient treatment followed by supportive outpatient treatment, which I think at a minimum should be done, because the idea is that you learn from this, because something is going on. And
Notice what the judge is doing here. This has moved beyond the mechanics of sentencing. The judge isn't just discussing penalties, conditions, or legal consequences anymore. Instead, the focus shifts toward the choices, habits, and thought patterns that brought the defendant into the courtroom in the first place. That's usually a sign that the judge sees a deeper problem than the charge itself.
the coping mechanisms that are being used, they're just not good, because we don't want another death. We don't want you to make some kind of decision that has a lifelong consequence, that where you end up in orange for the next 50 years, you know? Are you working at this time? Well, obviously not right now, but were you?
Yes,
What were you doing?
I worked at an equipment shop.
Do you still have that?
I probably not.
Hey, I guess we need to give him some time, you know. Can we apply for TAP funding for him? Okay, I'm gonna try to apply to get stuff paid for you, because I know that there's some, you know, funding that is available for people if they qualify, and I think you do. You have to understand, in this life, you don't have anyone that's going to bond you out. When you're out there, if you make the wrong decision, you're stuck, as you now see. You know, really, it's not that hard. Now, what we're doing is you're pleading guilty to the DWI. The DWI is going to go on your record. They're going to dismiss the terroristic threat. But you need to understand that forever and a day, if you get pulled over, what does an officer do? They first look at your record. If they see that you have a prior DWI, they roll up to your window and they smell alcohol or dope. It's probably not going to go well for you. And now, after today, you're facing a minimum of 90 days in jail for any new cases that you pick up. Do you understand?
Yes, sir.
The agreement that you have worked out is a 1 year in Harris County Jail to be probated for 15 months. You must do, is this a true first?
I believe so.
Or Proctor, if you don't mind looking at
Yes,
it, please.
sir. This is a true post,
Okay, so it's 1 year in jail to be probated for 15 months. You must do a DWI education class, 2 victim impact panels. Well, we've already done the TRAS, so these are the conditions. You've already done the TRAS, so that's not a need. No drugs, alcohol, substance abuse treatment. No breath test refusal. If you are pulled over, an officer asks you to submit a breath test, you must do it while you're on this probation. Can you look at him, see if his license is down? No, you must maintain a guardian interlock and 25 hours of community service. Do you have any children? Okay. If you do a parenting class, I will waive the community service for you.
He is not eligible.
Your license is not eligible. It got suspended, so you cannot drive at this time. So one of the conditions I'd like is for him to get his license back. Your license got suspended because of an administrative license hearing versus DPS, and I can have Mr. D explain that to you. You were giving up a lot of rights by entering into this agreement, Mr. Proctor. You're giving up the right to a trial, right to compel witnesses to testify on your behalf, confront and cross-examine your accusers. If you're not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization. You give up the right to appeal. Once you accept this agreement, you are stuck with this. If you ever have a problem while you're on this probation, you can always come back and talk to us. We can work through anything. If you just take off, that's about the worst thing that you can do. If you pick up a new case, that's about the worst thing that can happen. What about the complaining witness and the terroristic threat? Who is that?
The language in the text that you is
Here's a polished rewrite that keeps the courtroom commentary style while making the legal point more precise. : writing variant equals document ID equals 15684. This part is crucial, the no contact condition. People often treat it like a minor administrative rule, but courts generally do not see it that way. A violation can lead to arrest, revocation of bond, contempt findings, or jail time even if no new criminal charge is filed.
so it's not filed as a family hospital.
Do we know, did you have the rip done? Do we know if she wants to have contact with him or no?
Do group information when we want to proceed. Claire says she's fine with contact because she doesn't believe that if it harm.
Okay, just so that we'll just add no threatening or harassing contact with the complaining witness and the terroristic threat. Just be mindful, what is threatening or harassing doesn't matter what you think, it's what she perceives. All right? How do you plead to the offense, guilty or not guilty?
Guilty.
I'm going to find you guilty. I will follow the agreement, waive all his fees. I'm going to waive all your fees. It's never about the money. I don't care about the money. Just do what you say you're going to do it well, so we don't see you again. All right, good luck.
Talk to me about the private license, yes.
Okay. All right, good morning, gentlemen.
Good morning.
All of you guys have picked up cases from another state, so we need to figure out what's going on. Who is Mr. Burnett?
Right here, sir.
Mr. Burnett, you are wanted out of Florida for the charges of battery, criminal mischief, grand theft in the first degree, and robbery by sudden snatching. Are you waiving formal extradition?
Yes, sir.
Okay. We wish you the best of luck. Who is Mr. Perkins? Mr. Perkins, you're wanted out of the state of Illinois for first-degree murder. Are you waiving formal extradition?
To go home? I mean, to go back to Chicago.
Yeah. Okay. Guys, I wish you both the best of luck.
I need signatures on them, Judge.
Yeah, done.
Their signatures.
Oh, Deputy Julian, do you mind? And then, what is it? Amy, who's the gentleman?
This is Gordon Stock.
Golden Stock? Gordon Stock. All right, good morning, Mr. Gordon
How you
Stock.
doing?
Also, they're going to use you with us today.
Hi, Katie.
Hi, Judge.
What's new?
Not much. I just got back from Cancun. What about you?
Man, life is good. Man, I want to go to Cancun.
It was pretty nice. Very pretty.
Anywhere is better, right? So
Yeah.
you said, is it, I don't see it on docket today. What was the last name?
Scott.
Oh, Scott. Wait a minute, Scott. Okay, Mr. Scott.
Yes, sir.
I see you now.
What?
You were wanted out of the state of Oklahoma for drug trafficking and a robbery case. Okay. Shh.
What's up, guys?
Your lawyer is asking for me to set you a bond. I don't know. You know, one of the main things that it concerns me are two. One, are you going to go back if we give you a bond? Number two, are you a dangerous person? Because I don't want to give you a bond and then you leave a wake of destruction on your way back to Oklahoma, because then, you know, it's not cool, right? So I don't know anything about you. The only way I really get to know you is by paper, because that tells me who you are. Amy, Tell me about Mr. Scott.
Yes, he wanted out of Oklahoma County, Oklahoma for conspiracy to commit drug trafficking, marijuana, conspiracy to commit robbery, conspiracy to commit kidnapping for extortion. The bond over there is 1 million. This was issued April 3rd of 20 this year.
Shreya?
Judge, Mr. Scott is 34 years old. He's never been arrested, no criminal history. He's lived in Houston his whole life. He is a Navy veteran and served 8 years, honorably discharged 2021. And again, I've spoken with Mr. Scott, well, without going into the facts or anything like that.
This is a classic courtroom strategy. Notice what the defendant is doing. He's not arguing legal technicalities or attacking the evidence. Instead, he's trying to show the judge who he is outside of the case. He talks about his military service, he talks about his business, he talks about his child. Why? Because bail hearings and detention decisions aren't just about the charges. They're also about risk. Judges want to know whether someone has strong ties to the community, stable employment, family responsibilities, and reasons to return to court.
He says he's absolutely innocent and wants to go turn himself in and let them know and handle the issue. He also has a plan to return. We talked about going back within 14 days. I urged within the first 5.
Yes, sir. Yes,
Did I
ma'am.
miss anything, Mr. Scott?
No, ma'am, we did.
Do you have anything else to let the judge know about whether he should give you a bond?
I'm not a criminal. I'm not I don't know what the word you said to the public. I have no risk. I'll be down there in 4 days. My pops will drive me down there. I want to go ahead and get nipped in the bud. I'm already working on a lawyer. I'm just trying to get down there and handle my business. I own a business on the north side, a vape shop. I have no criminal history. I have not been in trouble. I'm 34 years old. Got a 4-year-old son. Birthday coming up next month. I'm just trying to take care of my business.
State your position.
Judge, based on just the charges themselves and the fact that it is $1 million bond in the demanding jurisdiction, I would be opposed to a bond. I'm not seeing any extensive criminal history. I just see some like charges entitled crimes against person harassment.
I'm sorry.
Oh, you see what?
I see a charge that says crimes against person harassment, but that appears to be dismissed. And then I see a failure to appear out of Denver Police Department. But when I ran as history judge, that's what I'm seeing. But again, just based on the charges and the $1 million bond, I would be hesitant.
Your Honor, I have never had no charge or any of that. I have not been arrested. I don't know what she said.
I understand, but the severity of the charges scare me, Mr. Scott. You know?
100% understand. But I have never,
I believe you, but the problem is that I think that the amount and the type of charges are probably just a little bit too dangerous for me. You know, I give bonds all the times, but with the conspiracy to commit the robbery and then the conspiracy to extort, what was it again?